Kgorotsheko ya Magistrata ka Polokwane e šutišitše gape kgopelo ya beile molatong wa seopedi sa mmino wa Lekompo le Tlhogonolo Tšhauke yo a tsejwago ka la Shebe Mabhena o lebagane le ditatofatšo tše mmalwa go akaretšwa maiteko a polao, tshenyo ya dithoto le go tshwara sethunya ka tsela yeo e sego molaong. Go bolelwa gore o thuntšitše sefatanaga go la Ladana ka Polokwane kgweding ya go feta. Tiragalo yeo e tlogetšego monamedi ya go betše.
Kgorotsheko e be e tletše ošoro ka balatedi le bathegi ba seopedi Shebe Mabhena se ke ge kgalala ye ya mmino a tšwelela go dira kgopelo ya gagwe ya beila. O lebane le dipharamolato tše sennyane go bala maetekelo a polao, go betha ka nepo ya go kwiša bohloko, go swara poo a itlhamile le go swara sethunya seo se sego molaong magareng ga tše dingwe.
This includes robbery with aggravating circumstances, possession of a licensed firearm, negligent discharge of a firearm, assault with intent to do grievous bodily harm, and attempted murder.
Ramolao wa gagwe o kgopetše go šutišwa ga molato gore a ithute ka ga diteng tša melato ye tshela ya tlaleletšo.
I think it would only be fair for us to be afforded a chance to consult with him with regards to those charges. We were prepared with regards to the 3 counts, but now there's 6 more counts.
Molato o šutišeditše go ya go la bone le la bohlano gore a dire kgopelo ya beila.
This matter is postponed to the 27th of November 2025 for bail application. The bail application will begin at 14 hours.
Balatedi ba Shebe Mabhena ba nyaka gore a lokollwe ka beila.
Munno a one go ka yang montšheng a ya a berekeng o tšere mašheleng a batho a mošomo o tla boya rena re tlo make sure ya gore o atla
molao kgopela le re mokweleng botlhoko a kgone o tšwa kgone o bereka.
Molatofatšo o tla tšwela pele go dula ntlwana swiso go fitlhele ge a boa gape ka labone go dira kgopelo ya gagwe ya beila. Ya ke koketšo motao wa ditaba tša SABC Kgorotsheko ya Magistrata wa Polokwane.
Amaphoyisa bophe umculi owaziwa kakhulu ngomculo welinkompo ngamacala ahlukene okusolwa kuwo okuyicala lokuzama ukubulala esigamekweni okubukwa ukuthi senzeka ngenyanga edlule. Amaphoyisa athiwa dubula umshayeli wemonto okwathi umgibeli wasala elimele eLadana ePolokwane.
The officer who was arresting him, he just told me that there is counts of attempted murder or something like that, which is yet to be properly investigated. You know, my client, they called us this morning. In fact, we got called about 2 weeks ago, and we went to the police, and they told us there's nothing, like we were called by police to come to the police, present ourselves there. We did.
Amaphoyisa ashaqene emonto yomsolwa ukuze aphenye kabanzi ummeli wakhe uthi akakalifundi kahle idokodo lakhe.
How is that there's 2 counts of attempted murder, which is something we will have to look at. We'll have to check the charge sheet. We'll have to check what is actually happening. But from now, I can't really comment much on the issue because I'm not privy to the contents of the docket.
Kusenjalo lo mculi ubeseqashiwe emcimbini eminingi ukuze anandise ngesikhathi samaholide kaKhisimusi.
As for the charges preferred against the accused, he more often used firearms or knives, and in some instances clenched fists. The applicant has a propensity to commit violent offenses. The weapon which the applicant used, save for his hands, were not recovered, and now the accused want to be released on bail. If indeed the applicant tends to commit Schedule 1 offense when released on bail, it can as well be assumed that he hid the said weapon referred to above in order to again use them upon his release. All the offenses against the applicant involves an element of violence. I need to indicate this to the applicant. I, for one, do not have anything against the applicant per se as a person. It is the conduct and personality of the applicant that caused the court to invoke the provisions which it has read into the record. It is the accused person himself that can do a personal introspection into himself to avoid finding himself in conflict with the law. And therefore, he will be able to propagate or progress with the career that he holds. No one can stand on his way. But the circumstances are the ones that have caused us to find gathered here, interpreting the provisions of the law in order to check whether exceptional circumstances as required in terms of Section 60, subsection 11A of the Criminal Procedure Act have been proven, so that the court may consider that the accused be released on bail in this regard. That is what the law provides. That is not what this court on its own interpret, but is the law that is applicable to everyone, including yourself as an applicant. Having said, the court further again referred to the submission by both counsels and the state. They were quite informative, very clear, and to the point. The court is further satisfied that the accused failed to discharge the honors that exceptional circumstances exist, which if considered by this court, it will be in the interest of justice that accused be admitted to bail. And having said that, the application for bail for the accused is hereby refused.